So a good attempt, Ringera. So the answer is yes, as you have correctly put it, and that under Section 3 of the Law of Succession Act, free property means property which the deceased was legally competent to freely dispose of during the lifetime and which was not subject to another person's superiority interest. And the key legal authority is where we have the Matrimonial Property Act 2013, in particular Section 6, that defines matrimonial property to include the matrimonial home, household goods and effects, and other movable or removable property jointly owned and acquired during marriage. Now, Ringera, I hope there is another person. Okay, Albert, welcome. Now, at least you will be two. Albert, this question goes to you. Now, Albert, a part of a will has been torn by mistake. Will that torn part survive? Can it be administered before the courts?
Thank you, Doctor. I just joined. But from your question, if the will has been torn by mistake, it does not amount to revocation of the will. And there is a case law to that effect where someone who had even written a will and it was torn, some of the pieces were collected and joined together just to see what the testator really intention was. So if a will is torn by mistake, I believe it doesn't form grounds of the revocation or destruction of a will.
Okay, that is well captured and you have correctly gotten the points. Relax, the questions are sasa zinaanza kupoa heavily. Sasa kupoa heavily. Ringera, what amounts to suspicious circumstances when it comes to issues to do with wills?
Where attestations are not properly done, so where there might be that a witness's signature might be missing, or the testator's signature be missing. Other than that, where where the practitioner or the person whom is facilitating the development of this will is otherwise the most beneficiary to the proceeds of the will. That's what I have in my feet. Albert can assist me.
Albert?
Yes, other grounds that can make a will suspicious, they are indirectly linked to the mental capacity of the person. Let's say if the testator is not able to recall or capture all his or her assets or the properties, or if the testator cannot capture or recall all the beneficiaries, especially their immediate family members. In that instance, we can say that will be highly suspicious and it could have been influenced by an external factor.
Thank you, Ringera and Albert. Now a follow-up question to Albert. Is suspicious circumstances on its own justifiable grounds for revocation of a will, or what else will the court require?
Suspicious circumstances itself, it's not a justifiable ground per se to revoke a will, because mere suspicion does not form a ground. However, the party or the party claiming suspicion or alleging that suspicion has a duty now to discharge that proof by showing maybe there is some illegality or fraud that was conducted in procurement of that will. Maybe a person was coerced or wrote the will under undue influence, or yes, basically the other grounds of illegality, they have to be proved, but mere suspicion itself is not a standalone ground to revoke a will.
Thank you, Albert. That is the correct answer. Chadwick and Rebecca, welcome. This question goes to Rebecca because she was the other person to join the meeting. What factors will guide the court in determining reasonable provision, Rebecca? Any three factors that will assist the court in determining, will guide the court in determining reasonable provision as provided under Section 28 of the Law of Succession Act.
Honestly, I'm not familiar with the factors. I only understand that if one, but perhaps I can give it a try, if one has not been reasonably been provided for under a will, or they've been left out, instead of applying for revocation, because as a beneficiary, being left out does not automatically amount to a grant for revocation. However, you can apply for reasonable provision under Section 26. I'm yet to familiarize myself with Section 28. I stand guided on the same.
Thank you, Ringera. Sorry. Thank you, Rebecca. You have correctly gotten the first part. And if you look Section 27 of the Law of Succession Act, it says that the court will exercise a wide discretion as to the form and amount of provision, and it will rely on the following factors. So it is important for us to understand the nature and amount of the deceased property. This includes the size of the estate, liabilities, and point number 2 is the past, present, or future capital or income of the dependent. That is also a factor that will be put into consideration. Then you have existing and future means and needs of the dependent. Then you have whether the deceased made gifts or settlements during his lifetime, because if he made those gifts or settlements, those will also be considered in this situation. Then what was the conduct of the dependent? Then what is the situation and circumstances of other dependents and beneficiaries? If there are minor children, the court will also put into consideration. Then what are the deceased reasons for not making the provision? They will analyze these reasons. And then you have general circumstances like fairness, family structure, polygamy, matrimonial property issues, and estate preservation. Those are the issues surrounding the discretion of the court to award reasonable provision. Now, Mr. Chadwick, can a former spouse successfully seek reasonable provision?
Yes, she can, but on condition that she proves that she was depending on the deceased prior to his death. So the court will look if she under Section 29 of the Law of Succession Act.
Were you aware of the amendment that was made by the Law of Succession Act, Amendment Act of 2021, that deleted the word former wives?
Not really, but I take that not.
Yes, so there was an act that deleted the definition of a former wife, and it substituted the words wives as compared to former wives. So that act, it is an interpretation where various lecturers have decided to say that there is an inferred amendment to the whole act, because if you look at the final act that is published in the Kenya Law Report, Section 29 still retains former wife, but if you read Section 3(5), it deleted the words former wife. So it is implied that that definition will also apply to other provisions of the Act. So be keen on that. Lecturer can can hammer you properly. Now, Mr. Yes, Mr. Chedwick.
So is my answer correct?
The lecturer will be expecting you to say the recent amendment. So you'll be caught off guard and you'll have failed, because the new position is that former wives was deleted. We only have wives. Okay, Mr. Chedwick. So former wives, maybe to answer you directly, they don't have a position in the Law of Succession Act as dependents. Yes, Albert? Yes, Albert, you can go on.
Okay, thank you, Victor. I think in relation to that question, perhaps the rightful position should be considering the amendments in the Laws of Succession Act, whereby the word former wives was replaced with the former with spouse. Now, if you ask, for instance, if a former wife can claim for reasonable provision or as a dependent person to the laws of succession, you can give that answer in two perspectives. Number one, the general answer from the setting of that question is that it's no, because of that amendment. However, if that former wife, in quotes, is coming to claim for provision, not in his capacity as a former wife, but just as a dependent. Let's say the deceased, even after their marriage collapsed or after divorce, used to provide or take care of the needs of that former wife, not in his capacity as a wife, but just as someone whom they know. Because you know, after divorce, you usually go back to default. It is assumed that you don't know each other again. So if she will be coming in her capacity as just a dependent, like any other dependents who are not biologically sons or daughters of the deceased, then she can claim reasonable provision, even though the threshold might be higher. So perhaps if you can just bring that aspect that she won't be coming to claim in her capacity as a former wife, but if she's able to prove she was, let's say, being paid rent, being taken care of, insurance covers, health, food and stuff, she'll just come in her official, not in her official capacity as their previous marriage status, but just as a dependent, ile tu, like I just depend on you for survival. Then the court now can, and again, I think it's discretionary upon the court, so long as some contingent proof has been made. Yes, Victor, I see you are extremely shocked. I don't know if you have.
Yes, I'm shocked because you are giving life to Section 29, because Section 29 says, 29A says that we have wives and former wives who will not necessarily require to prove maintenance. Now, maybe to structure your question, your answer, you are now saying that a former wife, if she comes in her personal capacity and then she proves that she was being maintained, then you're saying that she will be able to fall under the reasonable provision grounds by the fact that she was being maintained. That is your averment?
Yes, her rights will rank equally to other dependents.
Now, what was the essence of? Okay, now let me now phrase this question to you. Why was the amendment effected? Why did we have to amend the definition of Section 3.5 to delete former wives and substitute with spouses?
Yes, that's why I said you will not be coming here in your official capacity as a former wife. Let's say this guy, assuming alienda tu akokota pahali huko, maybe someone who is needy decides to take care of them. Then among his beneficiaries, those people wako tu kwa hiyo list, yani he took them as their maybe son or daughters or maybe relatives, na walikuwa wanamtegemea ile genuinely kabisa. In that capacity now, I'm saying the moment they divorce, becomes a former wife, that relationship goes to default. It's as if they don't know each other completely. So on those
Okay.
grounds, maybe if he was maintaining that person on humanitarian grounds, that's why the threshold will be very high to prove. And hapo ndo watu huwa wanakosea, kwa sababu the moment you just put the aspect of former wife, section 29 inakupa based on the new amendment. So unless sasa ukuje tu useme huyu hata hatujuani kabisa, I'm just an orphan, alikuwa ananiokolea tu hivyo.
No, now you have made it clear. Yes, Rebecca?
Victor, I don't think if it's clear enough, and I believe from our previous conversation, we had an extensive discussion on the amendment that was made and how we should go, or we should discuss it going forward. So from borrowing from what we discussed, we say that section 3, if I'm not wrong, it was amended to define a wife as a spouse under the Marriage Act. So if you are not, we will say you are not a wife if you are not considered as a wife under a spouse under the Marriage Act. And under the Marriage Act, definitely a former spouse is not a wife under the Marriage Act. However, section 29, while they were doing the amendments, and section 29 was also suggested to be amended, but they did not amend it. They left it as it was. So as at now, under section 29, a former wife is still a dependent. However, now we should have like the extent to which they can be a dependent. Like, unlike the present wife, a former wife, while they're still dependent under section 29, you can discuss it further because we were told to use the Blossom taxonomy, something like that, whereby you give this is the law, you analyze it, then you conclude, and what is your view on it. So while section 29 provides that a wife is still a dependent under the law of succession, however, there should be an extent to it. For example, you've gone through the divorce, you've just completed it. Let's say you've been given what's the name of this? Yeah, there's usually
Decree absolute.
Yes, thank you. You've just been given the decree absolute. You are yet to complete with your matrimonial proceedings, like you are yet to divide the assets. So if that, we cannot say really you are not a dependent on that estate. So you are still a dependent, unless say also if the disease was giving you like alimony. Let's say you had an agreement that in case you divorce me, there's this and this that you should be giving me, though there is a case that says otherwise, that alimony should not be, like, it's unconstitutional or something of that sort. However, if you were given alimony or you are being maintained by the disease even after the divorce, then why not? You are dependent and you can seek maintenance under section 26, and not maintenance, reasonable provisions, in case you're not provided for. Yes.
That is well captured. Albert?
Yes, thank you. Just final wrap up. From what Rebecca said, it's very clear, and I fully concur with her. I know sometimes we are given this conclusion. We just say that a former wife is not a wife for the purpose of succession under section 35, right? But she can benefit and claim for reasonable provisions under section 29. So she's not a wife under section 35 for the purpose of succession. But if it's for reasonable provision, yes, she can. That is the simple conclusion.
That is now conclusive. Albert, you did a blog. Can a husband claim alimony?
No, leave alone a husband, even a wife. There is a case law which declared the concept of alimony unconstitutional. So right now, if you are married and you get divorced, there is nothing like alimony, even though it exists in their jurisdiction. But in Kenya, it was declared unconstitutional, and you cannot pay for alimony.
Thank you so much for that. Now, Mr. Martin, welcome. Now you will be next after Brian. Yes, Rebecca?
Was the law amended? I believe under the Marriage Act, there is a provision for alimony, maintenance. Or the same is yet to be amended?
The same is yet to be effected, but it was declared unconstitutional. The jurisdiction of the court, Albert, was it a high court or court of appeal?
I believe it was a High Court decision. Let me just pull it up.
Okay, as you confirm, let me grill Ringera. Ringera, can you revive a revoked will? And if yes, what are the ways that you can revive a revoked will?
You cut me on my feet. Can I pass on?
Yes, choose a person. Choose Martin.
Martin, welcome.
Well, thank you. You also caught me on my feet, but what was the question? I've just joined in. What's the question?
The question is, can you revive a revoked will?
I believe you can through a codicil, if I'm not wrong. Say again.
Would
Just,
you be-
let me get the question again. Let me get
Yes.
ask the question again, sorry.
The question is, can you revive a revoked will?
Yes, I think through a codicil you can be able to revive. You can be able. You can through a codicil, but also I also want to imagine that it depends on the revocation that you have revoked. For example, if it's a will that has been revoked through destruction, total destruction, then that will cannot be revoked. Cannot be revived, right? But if it was revoked through express writing or through the through a codicil, then I believe you can actually be able to do again an express writing and say, by the way, I want to revive that will that I had done. Yeah. So I'm not too sure whether you can be able to revive. There is that also by conduct. For example, a will is going to be revoked by the act of you marrying somebody else or through a divorce. So I just want to imagine if in the event that you have divorced and maybe you remarry that person, I don't know whether there is anything like that, but I'm just trying to imagine, could that also be able to revive the will that you had before by the act of you marrying this person, remarrying this person again? I don't know, but I want to imagine that could be it. But I think codicil will be the most appropriate avenue that you can be able to revive a will.
Thank you, Mr. Martin. Now you are narrowing down to my exact question. Do you apply codicils when you are doing a revival of a whole will or part of a will?
I think when you're doing a codicil, a codicil is supposed to be able to, because if you were to do a whole will, why do you have to do a codicil? So a codicil, you'll only be able to probably revive some sections of the will. Probably not only maybe section of the will, probably you have some property that you have acquired that you want to be able to include on the will. Probably there is this notorious son you want to disinherit, so you do a codicil to disinherit the person. Probably you have gotten this shungwa you want to incorporate. So by and by as you move along. Yes, so I think that for me, I'll look at it from that perspective. But you cannot be able to say that you have a codicil that's going to revive an entire will. That would be like doing another will. So you have a will that writes the other will. So you automatically revoke the older will by the act of having a new will altogether.
Thank you so much, Mr. Martin, and you have correctly captured what Section 21 of the Law of Succession Act says. If you read Section 21(1), it says that a wholly revoked will cannot be revived except by re-execution. And Section 21(2) says that a revoked part of a will cannot be revived except by re-execution or by a subsequent will or codicil showing intention to revive it. I'll repeat because when it comes to a part of a will, that's where you'll have a difficulty. A revoked part of a will cannot be revived except by re-execution or by a subsequent will or codicil showing intention to revive it. So up to that point, you have directly captured what we intended. Now I'm moving from revocation of wills. I'm going to test another concept, and the concept that I'm going to ask somebody, Will Kister, welcome. What is a class gift? Will Kister.
Okay, thank you, Victor, for the question. I hope you can hear me.
Yes.
A class gift is I don't want to use the same words to define. A class gift is a part of the estate of the deceased that was given to a number of people who belong to the same category. For instance, where the deceased, let's say, said, this property to go to my grandchildren, then in that case, the grandchildren fall in the same class. That's what I'd say about that question.
Thank you so much, Kister. And a practical example is where the deceased wrote that this car is to go to my children, and then he has a lot of children, then that is what will fall under a class gift, because it is because that is what forms now a certain class of individuals to it. Now, Mr. Chedwick, can a beneficiary be a witness in a will?
Yes, beneficiary can be a witness in a will. However, if the beneficiary signs, they need to be two more witnesses to witness the same.
That is a very good interpretation from that. Rebecca, distinguish alteration from revocation.
You put me on the spot. So I'll okay. I'll start with revocation. Revocation, this is whereby revocation of a will. This is whereby you are doing what? Yes, revocation is whereby you are cancelling your will. You do not wish to. You do not wish your intention that you declared to continue in the same way. So you revoke it, and under section 17, you should have capacity to write a will. The same capacity you had while writing that will, you should be in the same capacity for you to revoke your will, and you can revoke it by the means provided under section 18. Well, alteration is just to alter, just from the word alter, amend, something like that.
That is the answer, Rebecca. Thank you so much. This question will go to Ringera. Ringera amejificha. Ringera, I'm looking for look for one photo. Ringera, how do you assess testamentary capacity?
To assess testamentary capacity, we go down to the general rules in capacity. We would begin with if one was not an undischarged bankrupt, if one was of mental sound mind, if no transaction was entered into by means of undue influence, coercion, or such, which would now say that the person in the right state of mind, and of course observing such things as oral wills, where you find that it must be stated within the last 3 months of the not oral wills, but things like gift interviews. It must be stated within 3 months of the testator's demise.
Thank you so much, Ringera. Oliver, are you in a position now to be cross-examined? Oliver had indicated that he was in another meeting trying to salvage his last-minute contributions to his project. Now I'll throw this question to Mr. Martin to see whether he followed up our assignment that we had later allocated. Mr. Martin, can one revoke a resealed foreign grant in Kenya?
Can one revoke a resealed grant in Kenya? First of all, the resealing of grants happens when the deceased had property that was abroad, and there are two kinds of properties that we are looking at. So movable and immovable property, which in this case it means that property they are going to be dealt with the rules of where the property is located. But now, when you talk about revoking a will that has been resealed in Kenya, I want to look at it from two perspectives. Though I didn't do the assignment, but I'm trying to get it off my head. The fact that for the revocation of a will, number one, who revokes a will? It is the person who wrote the will. So I think a will that has been resealed in Kenya can only be revoked through a court order or something like that. I wouldn't imagine a situation whereby you can be able to revoke a will that has been resealed. You need to seek the leave of court to be able to revoke it. I'm not too sure, but I know you're laughing at me. I can see on the laughter.
Victor,
And I know I am laughing. I'm laughing because how can you reseal a will in Kenya? You only reseal a grant, Mr. Martin.
What are you? Oh, what is the question? Okay, that's right. Yes, the grant. Sorry, the grant. Yes.
Now, can you revoke a resealed grant?
Yes, you can. Yes, you can. I think you can.
The answer is no. And I've attached an authority to that. There is no. I've put an authority in the group because the only law about resealing of grants, it is on how to reseal, but there is no provision on how to revoke. That's the rationale of why you can't revoke a resealed grant in Kenya.
Is that the only reason?
Yes, that is the reason that was laid out by the court. I've even attached a screenshot of the same when he was doing an analysis.
I remember there is a time we were tackling that issue in class. I think section 70 something. Was it 77?
Yes, 77 provides for how you will reseal a grant. But it does not provide how you can revoke a grant in Kenya.
Is that not a lacuna? You're saying now the judgment just came, said, okay, interesting. I think maybe need to do a bit of research on that, Victor.
Remember, they can't do the legislation's work. They only apply what.
So then that should be a lacuna, isn't it?
Yes, that is a lacuna, definitely. But if you see various rationales to it, is to also justify or return back to where the will was made to avoid any fraud allegations, etc. Still on the issue about resealing of grants, that's a very potential area to be asked. And Mr. Martin, I believe I want to test your knowledge on it. allow me to ask a subsequent question.
Okay.
When it comes to movable versus immovable properties,
Yes.
how do courts say when it comes to resealing of such grants in Kenya?
I believe, and correct me if I'm wrong, and I'm just trying to remember my knowledge of the section 77. That for the immovable property, like a house, things like that, that cannot be liquidated, then you need to be able to use the governing laws of that particular country where the person is. So if it's land, how is it going to be dealt with in that circumstance? But for the movable properties which can be liquidated, I believe then you can be able to use the domicile law of the deceased person, where the person is domiciled. I believe that's the distinction of the two. But correct me.
Good. That is the correct answer. And what if there is a dispute on the last place of domicility of this individual? What legislations will the court resort to determine that issue? We have a person A saying the deceased was domiciled in USA, and another person comes to say no, the deceased was domiciled in Kenya. What will you do as a judge?
I think where you have a dispute of domicile, we want to look at number one. First of all, I think I'll be able to look at where did the person die, where they died, and where was their residence. I'm trying to remember some case law. I can't remember where it was, but I think in something to do. Is it Tanganyika, someplace? I think so. But some case law. But I think where his residence was. His residence was. I think I could be able to do that, but I'm not too sure. Please help me out on that.
Good, Mr. Martin. You always resort back to the Law of Domicility Act. There is an act known as Law of Domicile Act that defines the last place of the deceased person to be alive. That is where you will settle the matter and decide accordingly. Now, thank you so much, Mr. Martin. That area you are well read. Now let me test somebody on jurisprudence when it comes to wills. Will Kister, a person dies, and this person, before he died, he took a phone and recorded his audio, and then he died, but he was in presence of two competent witnesses. What form of a will that be?
Pardon?
There is a man who is dying, and before he dies, he has taken out his phone, he has recorded his voice in presence of two witnesses, competent witnesses. What kind of a will that be?
Okay, I believe that will be an oral will because it was made orally and before two competent witnesses. The fact that it was recorded doesn't change the nature of the will.
Correct, Kister. Now assume there are no competent witnesses, and then this evidence is laid out before court. The court is being told, hey, look, at the time when the deceased person is dying, we didn't have a witness who witnessed him making this recording, but this is him. How will you interpret that? What law will you use to maybe, will you administer that evidence, Kwanza, to begin with?
I am not quite sure, but I don't think so. Because oral will don't have exemptions where you can make where you can make them without witnesses. Maybe if it were a person who was on active service, then the rule of privilege would have come in. But in this case, we are not told the deceased person was in active service. So I don't think the same will be valid.
Good. Well, Kista, there is a decision that talked about audiovisual wills, the state of audiovisual wills, and the position is that Kenya still does not recognize audiovisual wills, whether when it comes to oral or written wills, it does not have a place in the Kenyan jurisdiction currently. That is how you must respond it, and it is a decision. If you search audiovisual wills, you'll see the reasoning of how the same was applied. Yeah. So, Mr. Chedwick, what is a resulting trust? Yes, Rebecca and Albert?
Victor, the same. I think on the decision that I was going through, the Ombajo case, I think what I got from it is that the court classified audiovisual wills as oral wills, but they did not really go to the extent of saying they're not applicable in Kenya because the case was in the COVID-19 era and what have you. So maybe you can clarify on what you are saying right now.
I'll also be interested if you send the decision, because the decision that I'll also send, it says that the place of audiovisual wills is not yet recognized. It is the parliament to amend the legislations to capture the growth of technology. Because now we have what we call deep fakes. What if somebody fabricates that and says that that was the voice of the deceased person? So there is still a lacuna there. But I'll also appreciate if you send the decision, then I'll send it in the group. Thank you. Thank you. Yes, I had asked Chedwick, what is the meaning of a resulting trust? Maybe in a general definition language, so that we understand. Yes, Albert?
Yes, I had a question before we go to the discussion of resulting trust. While Kista was completing, she said, unless if that oral will was given by the people who are privileged. I'm just wondering, what is the right position? Are those privileged wills not necessary for you to have witnesses for them to be valid?
I read somewhere that for you to claim about oral wills, you must call the competent witnesses, and these witnesses must corroborate each other. Failure for them to corroborate each other, then automatically that oral will be challenged and it will not stand.
Even for the privileged service.
Yes, because for you to claim oral will, there is somebody appearing on your behalf to make sure that the whatever you said, it is the true version that was said before them. So if you don't have a witness, then how will it be an oral will?
Yes, I also thought so. I'm just wondering if there is no witness at all. Who now will come and say, I had so and so give this will? I don't know what really differentiates the oral wills for the normal civilians and the oral wills for the armed forces and the marine marshals. Is it the time frame or is it the number of witnesses?
Both is still mandatory. I'm actually looking at the interpretation of, let me project the Law of Succession Act that I had analyzed, so that we will be getting answers directly from the Act. And let's go down to the oral wills. Section 9. Oral wills. Yes, sir. So it is, no oral will shall be valid unless it is made before two or more competent witnesses and the testator dies within a period of 3 months from the date of making the will, provided that an oral will made by a member of the armed forces or merchant marine during a period of active service shall be valid if the testator dies during the same period of active service, notwithstanding the fact that he had died more than 3 months after the date of making the will. So the only exception is on the month, and provided he was still in active service, but it does not invalidate the requirement
Yes,
of competent
yes,
witness.
That is the striking difference that I wanted all of us to understand. It's only on the period and not on the number of witnesses or availability of witnesses.
Thank you so much, Albert, for that. Sasa kutoa swali hapa sasa ni mzuri, unajua hapa ni moto. Now I have an Islamic person. Can he take a matter to the High Court? Mr. Ringera, can an Islam bring a matter to the High Court
Victor, we've
if
not
the jurisdiction?
gotten an answer on the resulting trust question.
Oh, from Chedwick. Yes, Chedwick, what is the resulting trust?
Okay, resulting trust, let me try, is an instance, let's say when a deceased person, let's say in the estate of a deceased person, there's a property that the deceased did not contribute wholly, because in the law of succession, the nemo dat principle applies. So let's say if someone else had contributed to acquiring of that property, then that is what will be called a resulting trust. So the property can revert back to the person. That's how I can explain it.
Chedwick, you are so close, because a resulting trust is where a person has registered a parcel of land in his own name on your behalf, and then you challenge it in court and say that it is from that act that your beneficial interest is accrued. It is resulting from that arrangement. That's how I've seen decision saying, but you can clarify from your end so that you also justify your end. Yeah. Now, Ringera, tell us about jurisdiction when it comes to Kadhi's court versus the High Court. Can a Muslim take the matter to the High Court? Let's talk about the pecuniary nature. Let's say he has met the pecuniary nature. If he takes this matter to the High Court, what factors will the High Court consider, or what law will the High Court consider?
So this issue concerns the thresholds to be met for you to draw whether to draw your matter at the Kadhi's court or draw your matter to the High Court. So ordinarily we follow the Kadhi's court manner, because if all the parties, for example, in this context probate, if all the parties and the parties we say beneficiaries are Muslims, but otherwise, if one of the parties is not a Muslim and would wish for this matter not to be decided under Kadhi's court, then the matter proceeds to the High Court. Then the other instance is where someone is appealing a decision of the Kadhi's court to the High Court. And the other thing is about the High Court being having jurisdiction over matters under the Law of Succession Act generally.
So will the High Court follow the Islamic laws? Yes, Kista, I hope it is a clarification.
Yeah, it's a clarification. What if the parties are Muslims, but maybe one of them does not prescribe to the jurisdiction of the Kadhi's court? Then in that case, can they go to the High Court?
Ringera, that is a follow-up question. Can you clarify?
So please come again. If one of the parties, I got it, but please come again. If one of the parties.
Okay. What if both parties are, or rather the parties to the succession cause are Muslims, but some don't prescribe to the jurisdiction of the Kadhi's court, they prefer going to the High Court? In that case, will the High Court have jurisdiction?
then this is also premised on the parties agreeing to be bound by Islamic law, because the premise is that for you to be bound by the Qadhi's court, or for you to draw your matter upon the Qadhi's court, then it means you profess the Islamic belief. So if you profess the Islamic belief, then you also agree in this particular instance to proceed to the Qadhi's court. Otherwise, if you do not agree for your matter to be presented to the Qadhi's court, the High Court has jurisdiction under the Law of Succession Act to deal with the succession matters. And I find there might be a provision on if there are specific experts or opinions required, then the High Court may call a committee on the same. I would like someone to also maybe follow up on that if they have some more information on whether you can the High Court can have some supervisory jurisdiction of a committee that is specialized where there is a technicality that needs to be agreed on Islamic. I don't know.
Thank you so much, guys. And because of time, that all those issues will be addressed with this question. This is a prediction question that I deliberately formulated so that we clarify on issues to do with Islamic jurisdiction. So Ahmed dies in Mombasa in 2024, leaving a written will that gives his entire estate to his second wife and disinherits his adult children. His first wife and children file a succession cause in the High Court and insist the Law of Succession Act governs the same because one child is a Christian and refuses to submit to the Qadhi's court, and Ahmed had allegedly converted shortly before death but was buried by Muslim relatives. The second wife objects and argues that under Section 2(3) of the Law of Succession Act, Ahmed was a Muslim at death, so devolution must be governed by Muslim law, and the will is invalid to the extent that it offends Sharia limits. I'll break it down so that we understand, so that when it comes to the answering part, we all know what we are doing. There is a man known as Ahmed, and Ahmed resides in Mombasa, and he dies leaving a written will, and this will categorically gives his entire estate to his second wife na disinherit his adult children. His first wife, so akona first wife na second wife. His first wife and children, now first wife wenye wamechujwa nje wanakimbia kotini kufanya a succession cause in the High Court, and they are insisting that the Law of Succession Act will govern this estate because one child is a Christian and refuses to submit to the Qadhi's court, and Ahmed had allegedly converted. Now the deceased man alikuwa ameconvert shortly before death but was buried by Muslim relatives. The second wife now objects everything and argues that under Section 2(3) of the Law of Succession Act, Ahmed was a Muslim at death, so devolution must be governed by Muslim law and the will is invalid to the extent it offends Sharia limits. Now, advise the parties on the following. Which court or courts have jurisdiction to determine this distribution? And B, what law governs devolution? And C, what is the evidential test for proving Ahmed was a Muslim at death? And D, whether the will can stand in whole or in part under Muslim law. The marking scheme read as this, that on issues of jurisdiction, the High Court can hear the succession cause, but if and only if all parties are Muslims and submit to that court. The Qadhi's court is the proper forum for inheritance questions, and refusal by any party will block the Qadhi's jurisdiction. Okay. Governing law. Remember, this is not the full marking scheme. Tutafika kwa application of the problem so that you appreciate. This is just an introduction. Governing law is that if Ahmed is proved to have been a Muslim at death, distribution or devolution will be by Muslim law, Sharia law, and not the LSA Act. Proof. Muslim at death is a fact proved on evidence, burial right, lifestyle, identity documents, and witness testimony. Conversion allegations must be proved. Wanapo nilieka deliberate, he was buried by Muslim relatives. So conversion, who is alleging, must prove. D, a will. Muslims' will cannot validly dispose of the whole estate to one beneficiary if it offends Sharia limit. because typically 1/3 without heirs' consent and or defeating mixed heirs, it will be enforced only to the extent consistent with Muslim law on consents. Hapo sasa tunaingia deeper to appreciate how these wills are governed. Let us look at the governing rules. Tunaingia kwa answers. Section 2 of the Law of Succession Act ousters the Law of Succession Act devolution for Muslims. And Section 2.4 as read with Section 2.3 in the cases, as we'll highlight below, is also a key identifier. And then Part 6 on administration applies so far as are not consistent with Muslim law. Don't worry, to clarify. Qadhi's court jurisdiction in succession matters is provided under Section 48.2 of the Law of Succession Act, and it says that Qadhi's court continue to exercise jurisdiction on inheritance for deceased Muslims. Appeals from Qadhis is provided under Section 50.2 of the Constitution of the Law of Succession, and there is a constitutional limiter pursuant to Article 175 of the Constitution of Kenya that says that if you want to go to the Qadhi's jurisdiction, you must consent or all parties are Muslims. So there is a consent part and all parties are Muslims. Let us look at various decisions on what they have held. Usually the case of Nazima versus Nasrin 2015, it says that Qadhi's jurisdiction is conjunctive. All parties must be Muslims and must have submitted, otherwise the matter cannot be forced into Qadhi's court. Then if deceased was Muslim, devolution is under Muslim law. That is the case of Hassan bin Chege. Then another decision, CKC, non-Muslim beneficiaries or those who don't submit can shift the outcome, and courts have held that Islamic law or Qadhi's forum cannot be imposed where parties are not Muslims and have not submitted, and the High Court may proceed under the Law of Succession Act in such a posture. Then Abdallah 2022 decision. A Muslim will is substantively constrained by Sharia, including the no more than 1/3 without heirs' consent principle. So a will purporting to give everything to one person is typically invalid to that extent. Now, application to the facts. Which courts have jurisdiction? Because there is a child refusing to submit and is a Christian, the Qadhi's court cannot exercise jurisdiction under Article 175 because you are applying what? The conjunctive test. Consent plus all parties must be Muslims. The High Court can proceed with the succession course. If in a hypothetical situation all parties were Muslims and submitted, the High Court could transfer or allow the Qadhi court to determine the inheritance shares. What law governs devolution? The threshold question is Ahmed's religion at death. If proved Muslim, Section 2.3 points to Muslim law for devolution at the time of death. But when non-Muslim parties are in the dispute, we have no submission to the Qadhi's court, the appellate authority shows courts may proceed under the Law of Succession Act rather than impose Sharia through the Qadhi's framework. Expect the High Court to frame this as a constitutional or jurisdictional constraint on applying Muslim law in a way that excludes or compels non-Muslims. Then issue number C, the evidential test. It's a fact proved on a balance of probability. Evidence of profession, practice of Islam at death, you check on ID records, community, family testimony, imam, mosque, burial rights versus evidence of conversion, church records, baptism, and consistent conduct. So in this situation, burial by Muslim relative is relevant but not conclusive, and the court will weigh the totality. But I had indicated that with a reason, because if you compare to mere allegation of conversion, but as you wait to a full burial right to Islamic religion, the burial right will carry the day that the deceased person died an Islamic person by that fact. Can the will stand wholly or partially? If the court applies Muslim law, the will giving 100% to the second wife is unlikely to stand as written because it conflicts with Sharia fixed shares and 1/3 limitation absent heirs' consent. So remember the principle yenye nataka ukari from here in case of anything. For Islamic laws, you can enter into a will, lakini kukuwe na 1/3 tuseme umepeana 1/3 of your estate to one of the wives, unafaa kuwa na heirs consents. If they consent to that move, automatically then it will stand. That is the key takeaway when it comes to about issues to do with wills, kuna hiyo issue ya 1/3 unaweza fanya research to understand it deeper. If the court proceeds under the Law of Succession Act because of the non-Muslim child, yes, Albert Aruto clarify, unajua hizo vitu. The will is assessed under the Law of Succession Act and not Sharia apportionment. Now, Albert, clarify to us exactly how the 1/3 limitation happens kwa ground as we call off the session.
Okay, it could be a clarification and as well as a question, because my understanding of that 1/3 rule is that a Muslim cannot will out more than 1/3 of their estate, not the other way around, that cannot will out more than 1/3 of their estate to one beneficiary. No, it's like you cannot will out completely 1/3 of their total net of your estate. Now among the hiyo third sasa ndo kuna au beneficiaries, not that you cannot will out more than 1/3 to one of the beneficiaries unless the other provisions say that has always been my understanding. So sijui kama unaweza pull out your exact provisions tuone, is it 1/3 of the estate or 1/3 willing out more than 1/3 to one beneficiary ndo iko prohibited.
Okay, I also have a follow-up question. Hiyo adhadi imeprovidiwa in the Law of Succession Act kweli? Unajua ina follow the customs of the Islamic religion. Hapa sio ni kama tutapata hiyo adhadi kwa the Law of Succession Act. Because it is not to be applied. They are not to apply it under this act.
Yeah.
Kista?
Okay, Victor, if I may, the 1/3 is for all beneficiaries. That's the whole estate that the Muslim can bequeath under a will. The other 2/3 is left to Quranic heirs. So that's what the Islam law stipulates.
In opposition to the recent Supreme Court decision, the 2/3 will go to the also child born out of wedlock. Sindio?
No.
So children.
Then you Fatumathman. If Fatumathman was a different case, we are saying here on part of willing out the estate, the person can only will out up to 1/3 of that estate to all beneficiaries. Then you
2/3 inaenda wapi?
Now, Albert, I believe what Victor was trying to clarify is whether the children who are born out of wedlock will form part of the beneficiaries who will get the estate that is left out in the portion of the 2/3. In that case, they would, because they are Quranic heirs. You can say Quranic heirs ni sijui children, vitu kama hizo. Maybe if I get my notes, I can clarify on the same.
Rebecca?
Well, I also have the same question with Victor on where the 2/3 goes. However, the position that Kista has shared is the right position, that you can only will out 1/3 of your estate. However, under the Law of Succession Act, under Section 5, it provides that any person can make a will using any religion. So Miss Anastasia's position is that if you are a Muslim and you've decided to will out the whole estate, that means you did not want to be governed by the Islamic laws. So it does not necessarily invalidate your will. It just removes it from the purview of Islamic law. Yes.
Thank you, Rebecca. Mr. Martin?
Now, thank you. I'm just confused about what Wilkesa has talked about, and probably need some more clarity. This 2/3, you think it is will to who? Who takes up the 2/3? You say it again? And I'm just wondering, who is this? Who are those? Sorry.
That's what I'm trying to confirm from my notes.
And also, I'm just wondering, with Kista, just to follow up on that. So, if, for example, you have a Muslim and I have one wife, and one child of seeming. So how do you apply that 1/3 rule? Distribution and then the 2/3. Where does the property go to now? This 2/3.
Okay. So the 1/3 will depend on how the Muslim wants to bequeath his property. So in this, it will be by way of a will, whereby the Muslim is allowed to give the property to anyone, let's say to friends, any person who comes to mind. But now they are limited to 1/3. So they can only bequeath 1/3 of their property in the will. So the remaining 2/3, according to I guess it's the Quran, is supposed to be left for the Quranic ayahs, those who are the ayahs who are recognized in the Quran. So that's what the Quranic ayahs are. So this is the nuclear family or extended family of the deceased person. Hao ndio wenye wanaitwa Quranic ayahs. So the 2/3 itaenda kwao. So I believe the Muslims have a way their property is supposed to be shared. Juu kuna tema alikuwa anasema class, sijui ladies wanapata kidogo, men wanapata mingi. So hiyo 2/3 itakuwa shared according to hizo rules za Islam. But for you to bequeath your property under a will, you are only limited to 1/3. And what Rebecca was also saying about testamentary freedom under Section 5, that's the position. I have sent that case law, the one for Mwangi vs. Mwangi, where the court said if the deceased Islam person decided to write a will, then you can't invalidate it based on the ground that he bequeathed more than 1/3. Yes.
Now it is very clear. I believe hapa ume explain hapo iko sawa, because hata nikiangalia nimefanya a Google check who amounts to Quranic heirs, unapata inasema ni these are consist of 4 males and 8 females. Alafu ukisikiza their definition kuna husband, father, paternal grandfather and uterine brother, that will form the 4 male Quranic heirs. Alafu kuna 8 female Quranic heirs, wife, daughter, son's daughter, mother, maternal or paternal grandmother, a full sister and a consanguine sister and a uterine sister. Hizo ndo categories venye wamejaribu ku break down. Yes, Albert, remember we are out of time. You can maybe make the closing remarks.
Yes, thank you, Victor. Thank you for that clarification. And I know we are out of time. But my understanding, I agree with you. Maybe to make it simpler, you see, if we are having the estate of a Muslim, let's say, if we quantify it into, let's say, 100 shares, right? It's just that Muslim, that deceased Muslim, during his lifetime or her lifetime, can still enjoy the testamentary freedom that any another person has, so long as it is limited to up to a maximum of 1/3. Remember, in this 1/3 that he can or she can will out during his lifetime, they can bequeath that property to anyone, including their children or friends or even relatives, right? And remember, it's not like the people who will be involved or amongst the 1/3 beneficiaries hawawezi kuwa among the Quran ayah, right? Ama hao ayahs, hawa bado ni the relatives, kulingana na venye umesoma tu ninio Victor, the parents, children, half brothers, half sisters, right? Sasa hizi ni zinaachwa for now the Qadhi's court to determine. It's like now taking the form of intestate succession. So let's say there shall be tested succession of up to 1/3, then 2/3 itakuwa intestate succession. Then on the number of shares, hiyo rule huwa ni hivi. For each 1 unit that a lady gets, a man gets 2. So we can still have someone being a beneficiary among the willed part yenye imekuwa willed out among the third, na bado tukikuja kwa Quran haya pia bado atafall under hapo kwa sababu they rightfully belong to that category. Now this is the intestate part now that the Qadhi's court has to determine out of that estate.
Thank you so much, Albert. Na kuna issue na consent. Yes. Yeah, up to that point tuko sawa, lakini kuna issue na consent nimeona kiarise. Can the heirs consent to the deceased person to will out more than that?
Now that is subject to discussion and perhaps case law. I'm not really sure about that.
Okay, sawa. Thank you so much. Hiyo ilikuwa imejificha, to be honest ilikuwa imejificha. It needs mtu mwenye anajua how that rule operates. Yes?
Can you restate what you've said?
Oh, I'm saying as we were doing an analysis
With what you've asked Albert just now.
Yes, nimeuliza Albert, I've seen an issue on consenting, that the beneficial heirs can consent to the deceased man willing out more than 1/3. Is that the position? That was my concern.
Okay, maybe we'll look on that.
Yes, Albert?
Thank you, Victor. Just a contemporary issue. I don't mean to offend anyone. Based on this discussion and considering the supremacy of the Constitution and the articles which provide that the Constitution shall be the supreme law and any law that shall be inconsistent with it shall be null to the extent of that inconsistency. I'm just looking at this rule which says for every 1 unit that a female get, the man should get 2 in the Islamic ratio of distribution of a deceased estate. Doesn't that directly infringes the right to equality or fair treatment of the boy child and female child? And if so, do you feel like there is a gap that maybe the legislators or maybe the religious groups or societies have, such that they can be amended and be aligned to the constitutional principles and provisions? We shall be going to interfere with freedom of religion.
Mr. Martin hata ameinua mkono.
I'm just thinking, Albert, and it's good you're bringing that up, because I want to remember, for you to apply the Islamic law, it means both of you have to profess that law, so that you can be able to apply the Qadhi's court and everything else. Yeah. So the case is, for example, unless now probably one of the parties, as has been pointed out, is discontented with whatever decisions or whatever direction that particular issue has taken, then now you can be able to bring it to the purview of the Constitution through the High Court. But I'm not seeing a situation where both of you are professing the Islamic faith and you have subjugated yourself to the Islamic faith, then you come back and you contest the same, and yet you're professing the same. So I think, for me, I look at it from that perspective. But at the same time, I want to imagine if somebody is prejudiced, so that if, for example, like if I'm a Muslim and I feel prejudiced, then I can be able now to come and exercise my constitutional right to be able to come and challenge the constitutionality of that provision within the Qadhi or the Muslim faith that is inconsistent to that extent. But otherwise, I think I think that's the way it is. So that even in the customs, unless there are those which are repugnant to the morality, then you can now be able to bring it out from that perspective. My thought though.
Alafu pia I was also thinking it out loudly. There is an article in the Constitution that talks about issues to do with Islamic laws will be determined under the Qadhi's court. Yani, if you look at how the Constitution was being promulgated, kulikuwa na vita kubwa pale Bomas, and one of the war that was being battled it out in the fact that the Islamic leaders walikuwa na feel ni kama wanafinyiliwa, so it went to an extent where lazima they could have been considered. So it is stemming from the constitution, and for you to declare something unconstitutional, basi the constitution hiyo kitu inaenda contrary or inconsistent to the extent of the constitution. So they made sure that it may appear in the constitution so that you can't declare any unconstitutionality arising. Then this comes to another thing that you can be asked in orals. Whenever umejipata constitution kama hiyo Albert, and you are a judge, you apply what we call the doctrine of reading in. Hii ilikuwa inaulizwa sana pia Supreme Court JSC interviews. What is the doctrine of reading in? The doctrine of reading in is you are interpreting provisions that could have sounded unconstitutional, but you are reading them along the lines of the constitutional interpretation. So your issue inakwanga very heated one, juu ina stem back to the history of the promulgation of the Constitution of Kenya. That is my thought.
Okay, as you look for another question, now who has the power or authority to amend those religious laws? Is it left to the Parliament of Kenya or exclusively for those subscribers of that religion? And if so, you see, I'm just looking at the sources of law and how they rank with Kenya. So if the constitution is supreme, then it means all laws under it, whether international, local, customary, or religious, should be consistent with the general rules governing equality and stuff, right? Anyway, it's a big discussion, but I'm just thinking out loud.
As Albert, you are thinking out loud. Help us to think out this question. Can you what are the essential elements for you to say that you have passed out a good gift in contemplation of death? What are the elements, and are those elements to be read in a mandatory nature? And will those elements apply to an immovable property?
Oh, thank you. Since you found me already thinking out loud. The few elements that need to be established for someone to successfully pass a gift in contemplation of death, right? First, there should be first capacity to deliver that gift. Whoever is granting that gift must be in ownership of that said property or asset, right? Then the other element, there should be delivery of that gift before the person actually dies. And then another element that has to be proved is that the receiver of that gift must not succeed by death the person granting the gift. So let's say if someone is gifted something, then he passes before that gift has finally passed to them, before the one granting that gift, it automatically collapses. Then another element is that there was an issue with the cause of death. However, okay, there are many cases that have established so long as the person giving the gift dies before the receipt of the gift, that gift will be held valid. However, there are some circumstances that it can be actually revoked. Let's say if the person is murdered or commits suicide. Suicide really? I think if he's murdered and there are reasonable grounds to conclude and say that he did not die in a way that was contemplated or in an unlawful way. So those are some of the things that you have to establish for that gift to pass successfully in contemplation of death. What was the second question?
Can you pass out an immovable property as a gift in contemplation of death? Yes.
Yes, so long as you comply with all the conveyancing process, or transfers. Let's say if it's a land or a sectional property, so long as you transfer it before your demise, it will pass.
Okay, let us hear Ringera. Ringera is he still in the meeting? Yes, Ringera. Ringera, can you give us the characteristics, the mandatory characteristics of what entails a gift in contemplation of death? Pass on to section 31.
So, for a gift in contemplation of death, it must have been made by a person who is in the near future, expecting to die of a certain cause of death. The person must have stated or made the will, or not the will, but must have donated the gift with the reasonable expectation that he's going to die out of that cause of death. The other thing is that he must have stated it within the last 3 months of his demise. I may have mixed up the conditions or something. But I don't know if there's another condition, but I just used them alongside. What? Okay.
Yes, I've asked this question deliberately because students who wanna confuse oral will, gift in contemplation of death, na inter vivos. Sasa, okay, a gift in contemplation of death ni alimake akiwa hai, so inaweza. Okay, tuta confirm, but kuna kitu nataka kuonesha. Do you see these characteristics hapa? Hizi. Courts have decided that these characteristics, unaona zina use the word and mandatory. So you must understand them ndio uweze ku-apply in any scenario ya examination yenye utapatiwa. A gift made in contemplation of death shall be valid, notwithstanding that there has been no complete transfer of legal title. Unaona? Hiyo ndio sasa point yenye Albert alikuwa anajaribu ku bring about. There is conduct, hand over possession, car keys, nini hizo. The person making the gift is at the time contemplating the possibility of death, whether or not expecting death as the result of a present illness or present or imminent danger. Only one. Inasema soma sasa ya pili. A person gives movable property, which includes any debt secured upon movable or immovable property, which he could otherwise dispose of by will. And umeshika your second category. Umesikia nikisema about immovable property. The only thing that is allowed is a debt secured upon movable or immovable property. So gift in the contemplation of death, in a presume it is a movable property. And there is delivery to the intended beneficiary of possession or the means of possession of the property or of the documents or other evidence of title thereto. And a person makes a gift in such circumstances as to show that he intended it to revert to him should he survive that illness or danger. And the person making that gift dies from any cause without having survived that illness or danger. And F, the intended beneficiary survives the person who made the gift to him, provided number 1, no gift made in contemplation of death shall be valid if the death is caused by suicide. And 2, the person making the gift may at any time before his death lawfully request its return. If you read the interpretation of this part, unapata kuna decisions zenye zinasema all conditions are cumulative. Unaona? Any limb, failure on any limb will defeat the claim. Hiyo ni decision number 1. Decision number 2, delivery or means of possession is the evidential pivot. Courts reject vague assertions of he said he gave me. So mpaka utuambie there were keys alipatiwa. Haya, purported land transfers after death cannot be a valid motus causa after death of the deceased person. Huwezi kuja utuambia ati hizi transfer zilikuja ati alipeana in contemplation of the dead na ashakufa. If a valid motus causa gift is proved, the asset is treated as not forming part of the deceased free property for distribution. There is a court of appeal hapa. It upheld finding that the deceased had done everything necessary to effect that gift. Caution prevented registration. Gift upheld under section 21 reasoning on incomplete legal title. Hii ni nini inapeanwa hapa? Ni shamba. 2023 Dhuranira versus Lauri. Shamba, court of appeal inakubaliana na gift, immovable property. Tunaona ni land parcel Ithima 2448. Unaona? So this is one of the decision where inakuja inatuambia mpaka lands. Okay, yes Martin.
So are we saying that movable can fall at the donis causa motus?
A good question, because hiyo swali tuliuliza our lecturer Mr. Tony Odera akasema you strictly stick to the section 31 of the Law of Succession Act na ime exclude immovable properties. Acha tusome hata hii decision tuone rationale, si ndio?
Actually, I think
wacha niwasomee ndo msikie. The Court of Appeal held that the deceased had in his lifetime gifted parcel Ithima 2448 to the respondent. The deceased had taken all necessary steps to effect the transfer, including obtaining land control board consent, signing the transfer, and lodging the documents at the lands registry. The only reason the transfer was not completed was the caution lodged by the appellant. Applying section 31 of the Law of Succession Act and relevant case laws, the court found that the gift was completed constitutionally and the deceased had divested himself of all the legal and equitable interest in that parcel. Therefore, the parcel did not form part of the estate available for distribution. The court further found that the distribution of the remaining estate was in accordance with the law. Considering both the principle of equality, it is said there was no legal or factual basis to interfere. So hapa kuna clarification moja Mr. Martin naweza make. Kuna gift inter vivos na gift in contemplation of death. Nothing prohibits you from giving a land kama uko hai as a gift. Jote wakati unafanya transfers kwa Ministry of Land unaambiwa kindly record the consideration. Kwanza wakinotice ni spouse. Are you giving out this land kama gift ama under love and affection? So ukichagua gift basi ni inter vivos uko hai. Lakini ukienda gift in contemplation of death you must meet strictly hizo thresholds zenye ziko hapo. Hiyo ndio maikiti kwa yenye inaweza ndana nayo.
So yes. Ricky, I totally agree with you. This is gift inter vivos. He told me that he quoted section 31 Is it 31 or 36? Na 31 But otherwise this is 31 gift inter vivos. Because you can be able to see the gift inter vivos passes only when you have been able to pass the title to the person during your lifetime. And all the intentions and purposes from that decision is very clear that it was intended to pass. The title was supposed to pass before the person in his lifetime, basically.
So at least hapo tumeweza ku identify the two distinction. So Albert, I believe now pay iko very clear. Whenever unaulizwa swali kama immovable property inaweza pass under gift inter vivos, JJ ndiye amejibu hiyo swali. You stick to what section 31 imesema categorically for gift ni conjunctive hizo zote. And by the way, briefly, unajua naweza assume tumeshika na tujashika. What is the easiest way ya sisi kushika these conditions ndio apply tu zikiwa zote ina examination situation? unaweza ishika tu na layman's language. Mimi nimeshashika movable property, lakini kama ni debt, tuseme debt secured, hii ni kama charge, debt secured upon movable or removable property. Sasa hiyo ni exception to immovable properties angle, so ninaleta movable properties na hiyo angle ya charge, alafu ninaleta mambo ya huyu mtu ana, at the time of making this gift, ana contemplate the possibility of death, atakufa either present or imminent danger. Alafu wakati bado ana make nini, kuna delivery of possession, alafu iko intended to revert to him akisurvive illness. So wakati ana survive ile illness or danger, hii gift itarudi na tuseme alikuwa na colon cancer, alafu aka heal from the colon cancer, alafu akakufa akiwa heal from the colon cancer, that will not be a proper gift in contemplation of death. You already asha survive that illness or danger, alafu akakufa na kitu ingine. Juu ingine hii inatuambia the person making that gift dies from any cause without having survived that illness or danger. So kama atakufa na kugongwa na gari na bado ako na colon cancer, automatically that means kama haja survive your colon cancer at the time yenye anagongwa na gari, hiyo ni gift in contemplation. Lakini kama amesurvive alafu akagongwa baadaye, that is not a gift. Hivyo ndo naweza sema. Alafu kuna hizo exception, suicide. Hii ndio angle yenye Albert kidogo alijichanganya. Ulisema si suicide ni murder. Remember tu ile inaitangwa the slayer rule. The slayer rule inasema if you are the beneficiary alafu umeparticipate in murdering this person, utachujwa nje. Lakini kuwa keen, decisions inasema it's not only murder but it can lead to a conviction. It is upon a conviction ndio utasema huyu mtu ndiye aliparticipate in murder. Sasa zingine examiner anaweza fanya you hivyo deliberately, aone kama you are quick to assume facts because kuna decision ilisema hivyo categorically. Don't come here saying that kuna death allegations ati huyu ndiye alifanya, alimuua, murder allegations, those will not suffice. It is through a conviction ama a judgment yenye imekuwa passed, na hivyo sasa those are the nitty-gritty zenye examiner anakuweka on your toes vibaya sana. Yes, Martin.
Vicky, I just want you to clarify something. The element B into the brackets where you're saying that the movable property, which includes any debt secured upon the movable property, all the immovable property. I think if you can discuss those brackets, we'll be very happy, just to clear my mind.
Yes, in my view, the land, the transfer of the gift itself kama land ndio iko prohibited, haiko allowed kama gift in contemplation of death. But kama kuna alikuwa amesecure a charge, sema ameambia kijana yake this land iko na loan na Equity Bank ya 2 million, nimewekelea charge over this land parcel. So when I'm dying, I'm allowed to give you this gift in terms of money. In terms of money arising from this immovable property. That is how I could interpret it. Kwa movable hii iko direct. Pia ni deni yenye na maybe imewekelewa kwa gari yako. Hiyo deni pia it can be gifted out. That is how naweza interpret, unless pia other members pia wanaweza jaribu pia kuinterpret on their own angle. Is it clear, Mr. Martin?
I'm still trying to understand. I am trying to imagine me being gifted a debt that has been secured on a movable property or immovable property. I'm just trying to internalize that. I don't know, is there a scenario question that can be able to help us get this clear or what? I'm totally incapacitated on that. If somebody can help me understand, I'll be very happy. But good attempt trying to explain that, because I'm trying to imagine when you say debt that has been secured on the movable property, what exactly are you saying? I'll understand, yes, when you gift me a car that has a debt that I need to be able to clear. And now then the one they secured, okay. That's very clear.
Martin, if I can explain on that, on a debt secured on a movable property, let's say if you have a car and then you want to get a loan from a bank, So you use the car as the security, whereby you go say, I want this amount of loan, you can value my car, and then you register a security on it. If I fail to pay, then you will use my car to get back the money you gave to me. Then in that case, you have used your car as security to get that particular loan because the car is movable property. So in that case, I don't know how that came up with regards to donatio mortis causa. Maybe Victor can now explain from there.
Thank you. What I'm actually concerned about is the immovable. The debt that you have secured in the immovable. So car can be able to understand that you
Yeah.
gift car na ilikuwa na kaloni sawa. Shamba, and you're saying it's only for movable. So that's what I'm just trying to be able to
Understand. Okay.
Yeah.
Maybe Rebecca can say something on that.
If I may give it a shot, I believe just like the way loans can be transferred, like a debt, you can transfer a property the same way you can transfer even debts. So this is your dad telling you, my son, you know what? I took out a loan in this bank and this land is secured. So in case I die, go pay it for me. So that's basically it. Maybe you will go and pay, then you get that property or something.
And what will be the means of possession of that secured loan of that movable property? So, okay. Of that
What if you begin the charge?
Guess what? So you get the security agreement or what?
You take the charge document to the bank.
Eh?
You'll be given the charge document.
Okay. So literally speaking, assuming Rebecca, you've been given that gift with your dad. So assuming it's that section of property that was developing, so he give you the charge document. I don't know. Anyway.
If for example, unasikianga kuna baba wanachia watoto madeni, like they literally do not have properties. So
what kind of a gift is that? Anyway.
It's a bad one. However, what if if you umepewa hiyo, you go pay out whatever the bank owes. See, there's maybe the higher value, the property will be discharged. Ikikuwa discharged, unachukua. Look at it on the positive.
I think so. Yeah. I'm just trying to be able to reconcile my mind. The immovable property at the bonus causa. What is causa? Yes.
I'm happy venye tuna analyze vitu hadi tunaona exceptions. Hii ikikuja in any scenario tuko sure hatuwezi jaribu ku mix up the concepts. Hiyo at least iko clear. Tutatafuta saa scenario zenye watu waliachiwa madeni ama watu waliachiwa pesa yenye imetumika kama charge. Sasa tutaangalia hizo scenarios. Sasa hii ni ile point yenye huwa naacha the panel now to reveal the hardest questions that they think they have. Inaweza kuwa current affair ama inaweza kuwa pia for law of succession. So the floor is yours.
Victor, can
Yes.
you try explaining from the discussion you've just had, your section 31 before you proceed?
Yes.
So I can give an example. For example, you loan out money to me. Yes, Charo, ama nimalize kuongea?
Unaweza maliza tu alafu Charo next.
Maliza tu, nilikuwa na swali lingine. Yes.
Tuseme sasa Victor, tuseme sasa Charo akuombe wewe Victor 5 million, right? Alafu Victor ukampatia Charo 5 million. Alafu ndio to secure the money, a security Charo akupatie shamba, asemi nimecharge shamba yangu hapa for example ikuwe as security. Si ni shamba ni immovable property. Now wewe kama Victor, sorry hiyo siwezi rudisha. Okay. Wewe kama Victor, of course you don't own Albert's land. You if at all he's going to default, you might sell it nini or now retrieve it, whatever. So you understand your M-Pesa na vitu. So I think what you can gift there is not the land. Wewe kama Victor, what you can gift hapo sasa, tuseme you want to gift somebody, unakumbuka Charo ako na deni yangu, so una gift hiyo deni yenye unadai Charo, niko secured kwa shamba. So for example ukufe, God forbid, mwenye uli gift, kama ina make sense, mwenye uli gift Charo kikosa kumlipa hiyo 5 million, anaweza uza shamba ya Charo. Does it make sense? So you're gifting the debt yenye unadai.
That makes sense. And it should be the right position.
By the way, tukisoma Willy Gachagua, si alikuwa amepeana mpaka madeni, amewill out madeni.
Martin. Umeelewa the new interpretation sasa?
So it is not maybe Victor, if you can be able to go back to that.
So the opposite of what you were saying. So badala ya wewe kupewa deni uende ulipe mtu, so ni yana kugift na kuambia ninadai mtu fulani, endo umdai uchukue hiyo pesa.
Okay, that makes sense now. That makes a lot of sense.
Thank you so much Jebet for clarifying that. Albert, pia tutaangalia decisions. Msione ni kama nimeignore. Albert.
Okay, kidogo before Albert take stand, maybe if she can repeat because kidogo nimepotea hapo. Akisema that someone anaweza giftiwa madeni, so like what happens to maybe mtu ana executor ama administrator hata akirealize that hiyo kitu that it's a debt na imegiftiwa, so maybe if she can repeat.
So Chedrick, I was saying, for example, you have a son, right? This is just an example. And then you want to make a gift to your son in contemplation of your death. And then you remember, Victor, I once loaned out money to Victor, 5 million Kenyan shillings, right? Na kwa kama security tumetumia shamba yake Victor. So you tell your son, nadai Victor 5 million, in case I die of, let's say, this and this and this, ukumbuke nimekugift wewe hiyo 5 million. Na akikosa kulipa, ile shamba yake ya Thika Road ndio ni security kwa hii scenario. Now, I don't know what will be used as an element. You remember the element, for example, if you're gifting out a vehicle, you can give out the keys. I don't know what will be used as a possession up or something of the sort. For you, the other element that needs to be fulfilled, but that's just my general understanding of that bit.
We can use the security document.
Yeah, thank you, Rebecca. That makes sense.
So does that mean that initial notice costs will apply to also immovable?
It's not necessarily immovable. It's just the debt. It's the niyo pesa unadai huyu. And then sasa, remember, the money he's I don't know what to use there, but iko secured na hiyo pesa. So you've not gifted the Victor's land. You've gifted the money that is owed to you. Right? Makes sense?
Victor, can I ask a question now? You said hardest questions, must they be on probate?
Anything.
Now, I was trying to go through your recording on insolvency, yeah? And I have this situation, which is, remember the prescribed, I was looking at digressions and 19 and reading them together with section 33, yeah? On the prescribed value and the threshold, eh? And that's 500,000. I think you said you needed to revisit on that, eh? The 500,000 and the 100,000 that is provided for in section 19 of the Insolvency Act, where you're saying you have the small bankruptcies of 100,000, and then you have the prescribed value of 500,000. Eh? So I need to be very, very clear about that, such that so you're saying that all the unsecured debts, if they are above 500,000, then can you clear that? I want to be very clear that you cannot be able to declare the person bankrupt. I needed you to clarify that bit.
Mr. Martin, let me be honest, bado sijafikia hapo. Nakumbuka nimeandika hiyo assignment, but bado aki sijafanya, to be honest.
Because I think what you're saying is that if you had a debt of like, for example, I have a debt, my creditors unsecured total debt is about $1 million, and my assets cumulatively can only lead to 500,000, then they cannot be able to come and claim. They cannot be able to apply for a bankruptcy order, isn't it? We need to revisit.
We need to revisit kabisa. But Brian, you're an authority to that. Brian, are you addressing that question?
I can also address that in addition to another question I had. So the threshold is that the debt has to be one that exceeds 100,000 Kenya shillings for you to make a bankruptcy order. But then again, even if you have unsecured creditors, let's say of $1 million, you see, and you yourself raise the petition, even if your assets do not meet 100,000, the process of bankruptcy will still have to go on, because the purpose of bankruptcy is to place you under administration. You see, the purpose is to place you under administration. Remember, when we talk about under administration, I might be having assets of less than 100,000 bob, but my monthly salary is 200k. You see, that is future earnings. That if this process continues, then this is money that my creditors can go after. So it's usually a very, very tricky issue, but the threshold is not on what you hold, as long as now you're not already under any bankruptcy regime, of course. That would be my position on that. But then again, as Victor has said, we will need to have a definite presentation on the threshold specifically.
In fact, yes, Mr. Martin, what I will do, I was analyzing the Insolvency Act, nenda kuchukua an explanation of how I interpreted that part ya prescribed bankruptcy. Alafu nitume only that part. Unajua niliongelea about where ime exceed, kuna debts where mtu ana claim. So kuna hiyo angle nataka to revisit na ndatuma kwa video ka short.
Yeah, I think that would be important. Well, there are two issues here. Number one, what my understanding of the prescribed value, you're looking at the value of the assets you have for you to be declared the value of the assets. So if they don't exceed 500,000, and you have this debt, you have these unsecured creditors that you need to be able to pay back. We're talking about unsecured. So if these total unsecured creditors cannot be able to be covered within the 500,000, then you cannot be able to get, you cannot be declared bankrupt. You cannot be able to get the bankruptcy order. And that's the clarity which I need you to help me guide, because it means you cannot be declared bankrupt. Just the same case, like for example, if the debt is below the 100,000, you cannot be declared bankrupt. And I think that is probably in the spirit and the fairness and we're coming with the fresh start doctrine. I'm not too sure, but I really need you to and probably give us some case laws on that as well. Thank you. But that threshold, especially, yes, I can clearly understand the minimum, which is 100,000 downwards. That if you have a debt that you're claiming to this guy, that is, you cannot declare me bankrupt because of 70k, 80k, right? But at the same time, you cannot declare me bankrupt if my total assets, if I have taken $1 million, Bob, and my total assets, all my asset belongings, they don't lead to 500,000. Even if I have $1 million, you cannot come and declare me bankrupt. I don't know. So probably that's what I need to credit, because I felt I was listening to recording and I saw like there's a bit of clarity that is required there. Thank you.
I beg to disagree. I beg to disagree, because what we're talking about your assets. For example, you remember there was a bank called KWFT. So KWFT used to give village women loans. Then they let you default.
Clearly state the sender's identity,
One day they ambush you, carry on away your spoons and plates.
Defense or overstatement don't automatically
you see
relations
what I'm trying to
as a
say
strict
is
monetary getaway.
the measure
A creditor's
of what
bankruptcy.
you can own, so that we compute it to see whether
Okay, so welcome back.
500,000.
So extradition questions.
And then again,
you don't understand what we mean
remember
by
for
the prescribed.
property, the test is objective. Their value is objective, depends on market rates, fluctuating things, appreciate and such. But what I wanted just to insist on is that the threshold is only if your assets are unable to meet your liabilities and your liabilities are more than 100,000 Kenya shillings. And I agree with you when you say that if it's 70k, then no one is coming for you if the debt is less than 100k. But the threshold is just about being that
bankruptcy level. So
yes,
if you look at section 3, regulation 3 of the insolvency regulation, it says that for the purposes of the act, the prescribed bankruptcy level for all other bankruptcies is 250,000. So Kenyan court. Mnasikia the audio?
Yes.
I'm projecting an audio.
Exactly.
Okay. Apply these regulations as a strict monetary getaway. A creditor's bankruptcy route under the Insolvency Act should not be invoked unless the liquidated or unsecured debt or aggregated debts is at least 250,000. Where the aggregate exceeds 250, courts generally treat the threshold as satisfied, and the court will move accordingly to apply Section 17 requirements, where we have service of demand, inability to pay, and no pending set aside applications, etc. So we can say where we can have aggregates that are beyond the 250,000 threshold, the same will still be adequate. So back to the presentation is that we have the governing rules. We have Section 17(2)(a) of the Insolvency Act that lays the threshold for statutory angle once we have decided that we have noted of a bankruptcy level being arrived at. So judicial interpretation when it comes to this part, we think that the High Court rejected the argument that some individual claims fell below the threshold where the aggregate statutory demand exceeded the prescribed minimum. Regulation 3 is read together with Section 17(2)(a) on aggregate debts. The case is known as Invesco Assurance Company Limited versus Dama Charo Nzai 2019. So basically, I decided to highlight directly Section 17 so that we can get the grapevine of what amounts to the highly tested part when it comes to bankruptcy questions. So Section 17 provides for a creditor may apply for bankruptcy order in respect of a debtor. So one or more creditors of a debtor may make an application to the court for a bankruptcy order to be made in respect of the debtor in relation to a debt or debts owed by the debtor to the creditor or creditors. Such an application may be made in relation to a debt or debts owed by the debtor only if at the time the application is made. So these are the things that you need to have looked at. We started with the preliminary part. We look at the regulation number 3 that fixed the prescribed bankruptcy level. So we have taken note that it is above 250,000 or equivalent to 250,000. So we are safe. What are the critical angles to consider? The amount of the debt or the aggregate amounts of the debt is equal to or exceeds the prescribed bankruptcy level that was 250,000. B. The debt or each of the debts is for a liquidated amount payable to the applicant creditor or one or more of the applicant creditors, either immediately or at some certain future time and is unsecured. So we'll still have an analysis of this part on its own. So let us proceed to the next requirement. The debt or each of the debts is a debt that the debtor appears either to be unable to pay or to have no reasonable prospect of being able to pay. And now this means this part is being interpreted conjunctively, and there is no outstanding application to set aside a statutory demand in respect of the debt or any of the debts. So basically, before creditor makes an application for bankruptcy order in respect of a debtor, do you know the prescribed bankruptcy level, 250,000 or above? Now, do you know the threshold that you must understand pursuant to Section 17 of the Insolvency Act? Check the prescribed bankruptcy level. Check whether the debt is for a liquidated amount payable to the applicant creditor. Check whether the debt, whether the debtor appears either to be unable to pay or have no reasonable prospect of being able to pay. Then lastly, because these things are mandatory, make sure there is no outstanding application to set aside a statutory demand in respect of the debt or any of the debts. So another key takeaway principle that you must understand is that defects or overstatement don't automatically defeat the process if the debt still clears the threshold or can be cured. What do I mean? Courts have treated some defects in the demand, including misdescription, overstatement issues as curable or not fatal, where the data does not show substantial dispute or prejudice, and the undisputed amount remains above the statutory level. Okay, so this is basically to tell you that if you ever encounter a situation where there is some defects in the demand, whether the parties have been misdescribed or there are some overstatement issues that have been made by the creditor who has done this application. So let that not confuse you. Provided the amount is undisputed by the debtor and it remains above the statutory level, this will not defeat this application. Principle number 3, once the threshold is met, court focus on Section 17 compliance and inability or no reasonable prospect to pay. What do I mean? Where the court meets, or when the debt meets or exceeds the prescribed level and the creditor proves proper statutory demand plus non-compliance, courts readily issue bankruptcy orders absent a substantial dispute or a counterclaim or set-off or crediblement or security proposals. That is the case of Diamond Hasham Laji versus Kajil Kenya Limited 2019. What are the synthesis and practical steps that you can deduce from this preliminary point? Plead the threshold explicitly. Cite section 17(2)(a) and regulation 3. Okay, and state the exact liquidated or unsecured amount and show it is above 250 or equivalent to 250,000. If relying on multiple debts, plead and prove the aggregate meets the threshold. Break down plus provide the totals before the examiner. 3. If the debtor attacks the demand for overstatement or defects, isolate the undisputed minimum and show it still exceeds 250,000. Then argue the defect is not fatal or is curable unless substantial dispute or prejudice is shown. So if an examiner tries to mix up some defects that were made when you are serving this statutory demand, you extract the undisputed minimum and tell the examiner that still the undisputed minimum is falling pursuant to the prescribed bankruptcy level. 4. If debt is below 250,000, the creditor bankruptcy petition should fail at the gateway. Use ordinary civil enforcement or other insolvency alternatives if applicable, but not bankruptcy. Okay? So whenever you encounter a situation where the amount is not above 250,000, go try other forms of recovery. Then another rule that I found to be highly tested was on authentication of documents. Rule 5. Okay, how? My guest Jika nimejibu swali.
No, I was
Yes,
actually listening to that recording today, and that's the reason why I had this question, and I needed that clarity, because if we go to section regulation 19 rather, which sets out the minimum value prescribed, they're talking about 500k minimum value of debtors' assets and 100k value of the small bankruptcies. And I that's what I wanted to find out, that this it's supposed to be interpreted to mean that if the accumulated total value of the debtor's assets is less than 500k, you cannot be able to take me
are reserved by the cabinet secretary.
Hello?
Hello, mnanisikia?
Yeah, yes,
Martin, you were explaining something.
Because I saw this to be a highly I don't know, I'm just trying to think in my mind that the CLE might and even the OROS might want to confuse us with this. I'm just trying to imagine that the 5k minimum value of debtor's asset. So if I have less than 500,000 shillings, you cannot be able to go and institute. I mean, you can be able to challenge that bankruptcy order application. The same case that if the value of the debt is below 100k. That's the point I wanted us to be able to clarify. So that if, for example, if my value of asset is above 500,000, then it means yes, the bankruptcy will be able to go on and you can be able to liquidate my assets. But if it's below, then even if I think I owe you $1 million and my value of assets, and remember that's why they're saying you have to be able to do the statement of affairs so that you're able to come and say this is my total assets, this is my total liabilities, and these are the list of my creditors, so that you're able to determine that. So that's the point which I needed us to clarify, and I'll be happy if you can be able to probably give us more scenarios on that, and so that you can be able to get more clarity on the same. Thank you.
Mr. Martin, that is well captured. So umesema ni focus na section 19 on small bankruptcies level.
Not section 19, regulation 19. Yes, get together with
regulation 19.
The bankruptcies that you're able to be sure.
Okay.
The reason being, I want to imagine that the examiner will not be strict. He's going to throw some tricky questions about that, so that they can be able to see how you apply that. Because you need to be able to apply Regulation 3, Section 17, 19 with 33. Thank you.
That's a very good observation, Mr. Martin. I'll make sure hapo pia mimi nimeenda kuelewa how we will consider that wakati mtu amekusuu na uko between the 500 threshold.
And Victor, still on the same recording,
What will
we
happen?
want you to, I know that day you were very tired, but I think you crossed over very quickly on the alternative to company insolvency, the administration and company voluntary arrangement, the CV. So I think if you can be able to revisit, even though you're saying you had done it before, but it will be nice. But you have those recordings, happy if you.
For the purposes of regulation sijafika kwa companies. I was deliberate on first natural persons,
Haujafanya
alafu
company?
turudi kwa companies. Sijafanya
Okay.
companies kwa hii regulation
Another video on
analysis.
companies. Kuna ingine
Kando tatu ziko
So,
tatu.
I had a question. Sorry for the interruption. But bringing us back to what we were talking about, movement of debts, I was asking now, if in the vice versa now you're not gifting the right to claim a debt, you're gifting the debt itself. So for example, I own 100 acres of land. These 100 acres of land is commercial or agricultural in such a manner that it has revenue. But on the other hand, this same land is encumbered to the extent that I have been making money on this land. I've been producing money, and at the same time, I've been paying loans to service a certain charge or something. So it is possible also for you to gift this loan, because now you remember for example, if for example the creditors want to move against an estate, they would move so fast. So for me to ensure that they do not move against the estate, and to ensure that now this my son is sorted, you gift it when you're still alive, so that you ensure that you settle your affairs. I think people, when people who do these things, such, they
So Hii si mchezo. Hii so I'll clarify hizo issues from my end pia. Kwanza hiyo point ya hiyo venye examiner anaweza kuchanganya hapo na hiyo value nimeshtuka. Acha nifanye thorough research on that, Mr. Martin na Brand's point. So now Jota Matayo imeisha, I can release parties to retire. The takeaway assignment ni about the prescribed levels. Na hiyo issue ya 31B interpretation of it when it comes to the debt. Watu wakuja na figures tukirudi. I'll greatly appreciate. Let us do that tomorrow. Alafu msisahau drafting elements za this week. Jizo drafting tunapiga Saturday usiku. Yeah. Thank you so much, guys. Thank you so much. So the meeting is officially ended.